Yes, sir.
All right. Good morning, everyone. It's December 5th. We're here on case FDN 25-156 concerning 4312 West Laurel Street. May we have appearances, please? First for the city.
Maria Pettis-Malcolm from the legal department.
Eric Cotton, zoning administrator.
Laura Marley, zoning coordinator.
And on the petitioner side,
Mark Bentley, counsel for the petitioner.
I'm Manassi, Director of Planning for Johnson Pope.
and are there any witnesses who plan to testify today?
Yes, sir.
If those who intend to testify, if you could please raise your right hand, I'm going to swear you in. Do you swear or affirm to tell the whole truth and nothing but the truth?
Yes, sir.
All right, we'll go ahead and start with just a preliminary matter. Mr. Bentley, you'll have ample opportunity to present any argument and evidence. What was your concern about the procedure set forth by the city?
Yeah, it was the, Mr. Schroth, it was the abbreviated timeframes. So that was my primary concern.
Understood. Yeah, you'll have ample time to present any evidence and argument that you desire today. So we'll go ahead and start with the staff presentation then.
If I can, Mr. Schroth, share my screen.
Yes.
Can you see my screen?
Yes.
Start. Good morning. Eric Cotton, zoning administrator again for the city of Tampa. This is a petition for review for FDN 156, 2025-156 for the property at 4312 West Laurel Street. The petitioner is Taylor Brugna.
You got it.
The authorized agents again are Mark Bentley and Ryan Manassi from Johnson Pope. The property is zoned residential single-family RS50, and the original formal decision request was to confirm the non-conforming status. As from the application, quote, property was built as a duplex in 1962 and has been occupied with two separate units ever since. I have the property tax card from when it was built. So on the next screen is just an aerial map of the location inside, which is highlighted in red. The to the west on the other side of Manhattan is a school, and it's mostly a residential development, and there's some PDs for non-residential or for multifamily residential to the north along Spruce. The previous zoning on the property was R1, which was in effect from 1956 until 1987 when zoning conformance took place. So when this property was allegedly built in 1962 as a duplex, it would have been, the zoning would have been only for single family residential uses. Let's skip to the next slide, please. This is a map of existing uses, and you can see the zoning is primarily residential single family once again. The highlighted property in pink is the applicant's or the petitioner's property. And you can see there's only one other property in the area that's within the 1,320 feet. That's not a single family use. That's for residential single family use, which is the pink side on the south side of Nassau. It's right out, it's just within the 1,320 feet. Again, the property was built in 1962, so 6 years after the implementation of the city's first zoning regulations. The property that's on Nassau, on the south side of Nassau, was built in 1945, which is 11 years prior to the implementation of the original R1 zoning on the property. This map we received from the property appraiser's office. a little hard to read, but it does show the folio numbers of the properties and the year they were built. So you can see this one, again, highlighted in red, was built in 1962. There's other homes built in the exact same time frame in 1963, 1964, 1957, and all those properties were built as single-family homes in conformance with the requirement of the R1 zoning designation. And this is just a summary of the nonconformities. This is just straight from the code. So 27-291 states that to be a nonconforming use, it had to be conforming under the former zoning code, which was chapter 43 when the property was zoned R1. As a two-family dwelling unit, the structure on the property was never conforming to the zoning either in 1956 through 87 or current RS50 designation. No evidence was submitted or reviewed by the city that shows this property was legally permitted as a 2-unit or a duplex property in 1962. At the time of permitting, the only use that would have been allowed there would have been a single-family home. And go to the next. And that's the next slide. Is this the questions? Do you have any questions, sir?
I do not.
Okay, thank you.
Attorney Pennis-Backle, do you have any questions, Mr. Cotton?
Yes, sir. May I proceed?
Yes.
Mr. Cotton, as you testified to, this property when it was built in 1962 had a zoning classification of R1, correct?
Yes, ma'am.
And for the R1 zoning classification, a single family use was the only permissible use.
For residential development, yes.
Now, you reference City of Tampa Code Section 291 in regards to nonconformities. You testified that in order for it to be a nonconforming use, it has to be legally permitted. Can you explain to Mr. Schroth what that means?
To be legally permitted, it would have had to go through the permitting process. So in 1962, everything was paper. We didn't have any of the technology we do now. But they would have submitted a building plan that would have shown a single family home, and that's what would have been reviewed by the building department back in the 60s.
If the property owner at the time this was built in 1962, it's your position that if it was built as a duplex, the property owner at the time would have received a permit for it to be a duplex?
Yes, ma'am.
And you based your conclusion or your decision in this matter or because you did not receive anything from the applicant, and now the petitioner identifying a permit was issued for a duplex for this property?
That's correct.
Now, does the code in your analysis of this, in order for you to make your decision, does the code allow you to also do your own research regarding this matter?
Yes, it does.
And upon your own research, were you able to discover any records or show anything that there was a building permit issued for this property to be a duplex in 1962?
No, ma'am. There was no evidence.
And so based upon the lack of the applicant, now petitioner, in your review, but based upon the lack of evidence or documentation of a building permit, is that one of the reasons why you denied the request for nonconformity?
Yes, there was nothing showing that when it was built, it was built as a duplex. That was enough evidence to me to make that determination it was built legally that way.
Also, on the slide that shows let me get it. On slide 4, that's titled Map of Existing Uses, did you also, in your comparison of the surrounding areas, what in your analysis of the surrounding areas, how did that also contribute to your decision?
When I was looking at the surrounding land uses, it's the only duplex in the area. Had there been other duplexes that had been constructed in that same time frame, there's a greater possibility that would have been permitted as a duplex. But again, when the zoning was first instituted in 1956, the R1 designation would not have allowed duplexes, and other properties that were built in that same time frame were all built as single family.
I have no further questions of the witness.
Thank you, Mr. Bentley. Do you have any questions of Mr. Cotton?
Yes, sir, I do. Before I get started, though, Ms. Pettis-Mackle, the new information exhibits that you're referencing, we're going to get a copy of those. Did you bring a copy?
I already emailed them to you.
Okay. Fine. Did
The PowerPoint.
All the exhibits that was emailed to you earlier this week, along with Mr. Schroth receiving a copy of it.
Okay. Mr. Schroth, what I'd like to do is I just have a couple questions for Mr. Cotton. Then I kind of want to lay out our case and then walk you through some documents. Unfortunately, you not being here, it's a little difficult, but please bear with us.
This is
Here, and I have paper copies of all the exhibits that were submitted by both sides. But before you begin your presentation, I have a question for Attorney Pettis-Mackle. Do you have any other witnesses other than Mr. Cotton?
no, sir.
Okay, all right. Thank you, Mr. Bentley. You can proceed.
Okay. Well, obviously, this is a de novo hearing, so I already noticed that the city's presented some information that wasn't in their response to the request for the FDN. So we have some new information too, which is authorized under the code. Mr. Cotton, did you author the FDN letter?
It was drafted by another individual, but I can go ahead and sign it.
Who was the other individual?
Miss Laura Marley.
So to what extent were you involved?
Ms. Marley and I review formal decisions for nonconformities together. She drafts up the letter, I review it and finalize it and sign it.
The city has purged most of its permitting records that existed prior to 56. Is that a correct statement?
I can't answer, I don't know the answer to that question.
How long you been zoning manager or coordinator?
Approximately 5 years.
So over the course of 5 years, you're not prepared to answer that?
I can't speak to what the city did prior to 56. I don't know the answer to that question.
Okay. Like during the course of your day-to-day routines, do you see, is it common to see records prior to 1956?
No, it's not.
The CITUS system is the city's most reliable permit archive database. Would you agree with that?
Prior to Acela, yes, I would agree with that.
So CITUS still exists today, correct?
No. So I just went offline in 2015-ish.
Yeah, but the actual database, you make reference to it.
Correct, the
during
database
course of your
still
duties.
exists, yes.
Yeah. And apparently Ms. Marley made reference to it in the FDN, actually. CITUS record for the subject property.
Yes, sir.
Have you ever rendered a formal decision where you didn't have a permit from the city evidencing legal construction prior to the date in question?
Yes, so yes.
So was that just based on circumstantial evidence?
It was based on the same evidence that was reviewed in this one, the bulk directories, property appraisers information, the same data that was used in this one.
So what if the property record card from the property appraiser said 1956? Would that have affected your decision?
If it was existing as of 1956 as a duplex, is that your question?
Just that one piece of evidence?
Yes, that would have weighed more heavily than one from 1962.
And I just have a question or two, Mr. Schroth, for Ms. Marley.
Is there any redirect by the city for Mr. Cotton?
I do.
Okay,
proceed?
we'll do that, and then you can call Ms. Marley as your witness in your case, Mr. Bentley. All right, please proceed, Attorney Pettis-Mackel.
Mr. Cotton, the CITUS program, is it when it was, well, are you aware of, or do you know if the CITUS program was just a database or was it just for permits?
It was a combination of, when it went online in the mid-80s, it was a combination of new permits would be put into that system, old comments that were previously saved on index cards and such, were then entered into the system under comments. And there's just other information from different databases from other public agencies were pulled into CITUS, I think, when it went online.
So is it fair to say that the CITUS program is like a record keeping program?
Yes, it's a large database of records.
Now, you were asked on cross-examination if you received a property records card from 1956 compared to a property appraiser record card from 1963 or 64, that the 1956 record would have weighed more heavily.
Yes, ma'am.
Can you explain that to Mr. Schrock, why it would have weighed more heavily?
Yes, ma'am. So in 1956, had a structure been existing as a duplex in 1956, when the zoning regulations went into effect, that would weigh more heavily. That would have shown that it was built prior or at the same time as the implementation of zoning. In this case, it was, the property record card was 1962, which was after zoning was implemented by the city.
So the key to that this property was built after the zoning regulation, the significance of it is that the zoning at the time that this structure was built only allowed for single family, correct?
Yes, ma'am.
Okay, I have no further questions, Mr. Schrock.
All right, thank you, Mr. Bentley. If you would like to begin your presentation or call your witnesses, we're ready for that.
Yeah, let's call Ms. Marley right now.
I didn't swear in.
Okay, I will swear her in. Ms. Marley, do you swear or affirm to tell the truth and the whole and nothing but the truth?
Yes.
Thank you.
Ms. Marley, who's your boss?
Mr. Cotton.
Mr. Cotton, on his direct testimony indicated that you were the primary author of the FDN. Is that accurate?
Correct.
To what extent, from your perspective, was Mr. Cotton involved in the analysis?
Quite a lot. We met on this case probably 5 or 6 times. He requested the map from the property appraiser. We went over all of the existing uses in the area. We looked up when the other duplex was in the record. We went over really everything together.
In the FDN, and I'm paraphrasing because I don't have it in front of me, but one of your conclusions, I think it's in paragraph 3, was that the FDN was being denied because of insufficient evidence. Is that fair to say?
Correct.
How do you define insufficient evidence?
Typically, we look for something that is directly tied to it being permitted a duplex, or a record that it was established as a duplex. Anything that we can base an approval or denial, an evidence-based piece of documentation.
So in preparing your analysis, you've got a lot of discretion in terms of the weight you put on any particular piece of evidence. Is that correct?
I review them all as one. If there's more evidence, it's always better. But I take a look at everything that the record had or the applicant submit.
Have you ever recommended approval of an FDN when you didn't have a specific piece of evidence that the structure existed prior to the effective date of the code in question.
Are you talking about 1956?
No, I'm just any FDN.
I can't answer that. I honestly can't answer that.
What I'm asking is just based on circumstantial evidence, you might have 30 pieces of evidence, but one of them doesn't specifically indicate that the structure was built prior to a change in the code. Have you ever approved an FDN?
Like I said, I can't answer that. I go in and I try to find any evidence that I can to support the
So,
approval or.
so your answer is you just don't recall?
Yeah, I mean, I do so many of these. I can honestly tell you based on what cases, what evidence they did or didn't have. I can't honestly answer that.
Fine, what I'm trying to find here is the documents for Derek.
Well, since he's on there, you tell me what you want to show,
Yeah.
but I don't have these because Ashley printed that out.
I understand.
Explain that.
Hey, Derek.
Can I share?
Yes.
Can I share my screen at this
Hold on
point?
a second.
What I intend to do is kind of lay out a roadmap. I wanted to go over a couple key documents that aren't in the record. Okay. And
Understood.
what I've done here is,
What do you want first? You want sign this?
well, let's make sure that the city has our,
I gave them the whole package
okay.
and they have the map.
So I just, for the record, anything that I reference is in the possession of the city. Okay. So what I was going to do right now is in our hearing exhibits, you're going to have all these documents, but I just pulled out a couple of the key ones. I wanted to, just pay a little more attention to those. And then at your leisure, you can read this stuff. And
Are these identified in any way by letter or number?
well, we can as we proceed. I think some of them are numbered.
Well, and
In our packet they are, Derek, we've got 6 exhibits. Okay, and
So, and I apologize. So, Mr. Schropp, they're labeled petitioners hearing exhibits 1 through 6. And it's a little, I don't know how they're going to modify it, but I've already presented the record. And from the email that I said, you'll see petitioner exhibit A, B, C, D, E. So I just, are you going to say it as 1, 2, 3, 4, 5, 6?
yeah, we'll do it that way. And here again, being de novo, there really is no complete record until the conclusion of this hearing, obviously. So first of all, the sole issue in this case is articulated in paragraph 3 of the September 12th, 2025 formal decision. And so the issue is there sufficient evidence that the duplex currently located on the site was constructed legally? So clearly you heard testimony from Ms. Marley. This is a matter of discretion. And also, when you think about it, Mr. Schroth, we're talking about having permits from roughly 70 years ago. Okay, no one keeps documents that long. I've been doing this for a pretty long time, and I've had cases with the city where you never have that smoking gun or that one piece of evidence, that makes things crystal clear. But generally, the city would evaluate circumstantial evidence and then arrive at its conclusion, and sometimes actually in a positive manner, notwithstanding you didn't have, for example, in this case, that permit prior to 1956. So the evidence will show that the use was legally constructed. The primary critical piece of evidence is actually referenced in the FDN and will be discussed and analyzed. So these cases where events, like I said, go back 70 years are difficult and really imposes an almost insurmountable burden on the property owner. Like I said, who keeps records for 70 years? And number two, the best sources of evidence, okay, to receive a positive recommendation or decision from the city would have been a city permit. Unfortunately, and you'll hear Mr. Manassi testify, is that the city has purged most of its older records. Okay, so it's impossible to track down that permit. So the first piece that I just referenced of evidence is the situs for this property, and Ryan's going to talk about that during the course of his presentation. And so that's Exhibit 1. And one thing Mr. Schroth, is what we have here is it's Exhibit 4. It's a copy of the 1951 City of Tampa zoning map, which identifies the zoning for the subject property as R2.
I was gonna show them the 51 first, because.
Yeah.
Sorry, we thought you were gonna be here, so we had paper copies, so I'll zoom in to try to keep up with Mark. So 1951.
So anyhow, we're going to give you the map, and we've identified the property and the zoning. This is the 51 map. Okay, and to our knowledge, this map was in existence prior to the enactment of Chapter 43 in January 1956. So it's R2. So a plausible explanation as to the events that transpired here again, this is somewhat speculative, but I can imagine that this being the official zoning map of the city, when the client went in to get, or the then property owner went in to get their permit, okay, the city might have just referenced the R2 zoning designation, had a story, issued the permit, and then the construction. I'd also like to point out is that I think the city in their FDN references like 20, was it Ryan, 26 makes reference, there's 26 points raised in their letter, and 13 of those points relate to what's called the Polk Directory. And the Polk Directory in the city of Tampa, it was kind of an advertising tool akin to the yellow pages or white pages. So here again, about 50% of the analysis related to the Polk Directory. And actually, a lot of it is favorable to our client because it demonstrates that there was never any clear intent to abandon the use of the property. And we can go through those dates later on, but under Florida law, even if a code says, a zoning code says that if you don't utilize a property, say, for example, like typically they'll put like 90 days or 180 consecutive days, then you divest yourself of non-conforming use status. However, in this case, with the Polk Directories, the city identified in its letter clearly shows there was no intent to abandon. So I just want to get that issue off the table. But one thing that's interesting about the Polk Directory, and here again, the city, 50% of their documents are referenced to the Polk Directory, is, and this is just an example, we picked 1962, and this is in our exhibits, right, Ryan?
He's not gonna see it.
Well,
But there-
he won't.
It's in the pack.
It's in the packet. But what we've done here is we've got this page, 1962 Polk Directory. And then we compare that to the property appraiser's record cards. And this entire block where the subject property is located is not in the Polk Directory. Okay. So I'm just pointing that out to you, is that,
Structures exist,
pardon me?
but the structures existed.
Yeah, the structures existed, and so this other exhibit we have with the property appraiser, kind of like what Eric did with his exhibit is we went through and identified the dates of construction of all the houses on the block. And you've got like, it goes from 1940 to 1962. But here again, none of them showed up in the Polk directory. So the Polk directory is interesting, but it's not totally reliable, obviously. So to not see the subject property in the Polk directory prior to 1956 is not a great mystery, okay? None of these houses were on this block in the Polk directory, even though they'd been there for 20-something years at that point in time. And then what I'm providing you with, and you're pretty familiar with these cases, is the case law kind of controlling certain aspects of this proceeding. For example, these are all appellate decisions. Okay, 2 of them are from our jurisdiction, the 2nd DCA, actually. And these cases, and I want to identify each one. You can just take a look at them. I think you know them pretty well anyhow. So they stand for the proposition that the permit is valid based on equitable estoppel, which prohibits the city from enforcing more restrictive zoning when a property owner relying in good faith upon some act or omission of the government has made a substantial change in position or incurred such extensive obligations and expenses that it would be highly inequitable to apply that code. It'd be unjust to destroy the rights that the person has acquired, which in our case would be the city's attempt to revoke a lawfully permitted structure, which has been maintained as such for roughly 70 years. And consequently, as a result of its existence, and no one had a problem with this property, obviously it's demonstrated that it's compatible with the surrounding area because it's been out there for roughly 70 years. So these property owners have been paying higher taxes based on the fact that the DOR classification by the property appraiser is a duplex. And I point out to you the Largo case where it says stripped of the legal jargon, which lawyers and judges have obfuscated it with. The theory of estoppel amounts to nothing more than application of the rules of fair play. And a citizen's entitled to rely on the assurances and commitments of the zoning authority. Okay, and if he does, the zoning authority is bound by its representation. These cases also stand for the proposition that zoning regulations are in derogation of the common law and are subject to strict construction in favor of the rights of a property owner to the unrestricted use of their property. So kind of like tie goes to the runner here. If there's any ambiguity or question about what one of these code sections means or how it should be applied, it should be analyzed, okay, in favor of the property owner. And finally, there's a presumption of legality, and I've given you just a one-pager out of Black's Law Dictionary. It says the very general presumption that people have acted lawfully unless and until contrary is proved, which would be the city's burden in this case to prove there was illegal construction or falsifying permit applications. So once again, the sole allegation made by the city is that it is not lawful construction because of insufficient evidence. Would not be problematic had the city not purged its records. So our guys never had an opportunity to even establish that it was illegal use of the property or that it had been out there prior to 1956. So that being said, we'll launch into our, unless you have any questions.
I do have one question. What has the use of the property been continuously for the last 70 years as a duplex?
Yes, it has. We'll show you some photos. You know, they're recent photos, but you can, and also when you compare the photos with the property record cards that show the dimensions of the house and the footprint, you'll see that it's always been a duplex. Okay. And
A duplex occupied by two separate family units?
yes, sir.
All right, thank you. Please proceed with your presentation.
And then like I said, some of the references to the Polk directory made by the city in its FDN actually indicate that it was being used as a duplex over, like, I think, 2 decades worth of information they have there. So why don't we go to slide 2, Ryan? Mr. Schroth, one thing I wanted to point out to you is when I was getting prepared, it came to my attention that in the city's land use element of its comprehensive plan, they actually take the general holding from the estoppel vested rights cases, and that's in the land use element, and it's in our PowerPoint as slide 2. And I'm not going to waste your time reading it, but basically it says equitable estoppel would apply if there's valid unexpired act of an agency and good faith reliance, et cetera, et cetera, et cetera. So that's the articulated policy that the city of Tampa through its city council, okay, to recognize equitable estoppel in connection with land use decisions. And if you want, we can actually go and get a copy of the land use element, but I would just incorporate that by reference. And my testimony today is that's the exact verbiage from the land use element under vested rights. Slide 3, Ryan. The code does not require proof that a use existed prior to 56. That's not in the code. Instead, the applicant must show that the use was legal when established and later rendered non-conforming by zoning amendment. Section 27-297 expressly requires the city to consider a broad range of evidence, including post-1956 public records, property cards, surveys, and folk directories when original records are unavailable. So with respect to these different forms of proof, we've provided everything that we could get. A lot of the stuff's impossible. Tampa Electric won't cough up utility records and things like that. The property records, property appraisers, field notes, they're somewhat incomplete. There's based on my practicing here with Hillsborough County property appraiser for several years, there'll be large gaps in the field notes. The slide 4. The denial letter finding section concludes that unless the duplex existed prior to 56, the zoning adoption, it cannot be recognized. And here again, that's inconsistent with the code. The code never states that a post-56 structure cannot acquire non-conforming use status, and the absence of a building permit from 62 cannot be treated as evidence of illegality, especially when the code provides alternative evidentiary pathways. These cases are based on circumstantial evidence. What would a reasonable person conclude after hearing all of the evidence? The city, to my knowledge, has issued NCU certifications without actual city permits prior to the change in the code. Slide 5. Although the R1 did not allow duplexes, the city has no evidence showing the duplex was illegally established in 62. Historical permits from that era are often missing. You heard testimony from Mr. Cotton General saying that was the best database or information that the city has concerning historic records. Historical permits from that era are often missing. 27-297-3 of the code recognizes this and allows applicants to rely on alternative forms of documentation, all of which have been provided. So the burden is not to disprove illegality, it's to present credible circumstantial evidence of lawful establishment, which the applicant has done. Slide 6. The evidence is inconsistent with the possibility that the duplex existed before 56 and was reconstructed in 62. If the duplex predated R1 zoning, it would have been lawful when established. Under section 27-297, reconstruction does not extinguish non-conforming use status absent abandonment. There's no evidence of abandonment, and continuous occupancy supports continuous use. Slide 7. For more than half a century, the city's own records consistently recognize this property as a duplex, which we'll go over in a couple minutes. The Citus database, 62 property card, multiple property assessments, and 5 decades of Polk directory all document duplex use. Slide 8, Ryan.
I'm going to jump in there for the next few slides and turn it back over to Mark. Slide 8 is going over one of the most compelling pieces of evidence, in our opinion, is the city's own internal Citus record, which lists the use as duplex. And again, under section 27-297-3, the city must evaluate public records like this in determining legal nonconformities. In the 1962 property card created at or near the time of construction identifies the structure of the duplex. This is direct evidence of legal establishment and must be credited under the code. And as Mark alluded to, these pictures were taken last week, and a few of them just to show the front and the rear. And as Mark stated earlier, you're going to notice the front has those 2 stoops or porches on the outside of the structure. You're going to see that same recognition on the property card, and I can pull that up separately, but just so you see these 2 entrances right here, and then there's a back porch, and that's exactly what is still out there today. Also on the right, you'll notice 2 meters. You know, that's not the clear definer of everything, but it does have 2 meters for units A and B. Another point, just for construction, you can see the house is made of block. So this is not, this is the original structure according to the property card. There hasn't been alterations, and it's in the same exact footprint as it was per the property card. A lot of times in Tampa, you see structures with janky additions to the back, but this is a completely block house in its original configuration. And so slide 11 is going over the continuous duplex occupancy. The city's denial letter references 13 Polk directory entries from 1968 through 2022, documenting occupancies of units A and B. Polk records are explicitly listed in section 27-297 as valid evidence of continuous operation. And these listings definitively show no abandonment for more than 50 years. So under section 27-297, the applicant must show continuous operation, maintenance, and possession of permits or applications evidencing intent to maintain the use. The evidence overwhelmingly satisfies all 3 requirements, and there's no evidence of abandonment or discontinuation. Now, what I'd like to do is just go over a little bit on the Citus information. The city has already relied on Citus information to confirm the historic zoning for the property, and I'll put the card up on screen since it might be easier to as I read this. Low power. The city's already relied on Citus information to confirm the historic zoning for this property. If the city considers the zoning information on this document to be accurate and reliable, then the other information on the same record should also be taken into account, especially since it consistently identifies the structure as a duplex. The Citus information includes 4 separate indicators showing the property is a duplex. The top center, the address is listed as 4312 West Laurel Street, units A and B, reflecting 2 units. The right side of the card, it lists residential units as 2. The left middle, the unit number field again shows units A and B. And the bottom left is the standard land use code or SLUT code. It's identified as 1620 with duplex identified. All 4 indicators point to the same conclusion. And now just some of my past experience based on my 7 years working for the city of Tampa, ending as a planning and development coordinator in zoning, I can confirm that Citus has long been used as a tool for reviewing historic zoning information and last legal uses. Staff would regularly rely on it to verify previous zoning districts and to confirm duplexes, triplexes, and other uses. Specifically, I recall that when rental certificates were being issued, the zoning staff, including myself, regularly relied on this information in Citus to issue those certificates whenever the data was not available in Excella, which is the city's current permitting system. This information included dwelling counts, just like the aforementioned. And with that, I'll go back over to the presentation for the conclusion for Mark. Slide.
So, Mr. Schroth, you had heard testimony that Citus is the most reliable and extensive database the city has, but for its new Acela system. And it archives historical documents. So in order to be in Citus, okay, these are structures that are permitted that end up in this database. So back to my argument about vested rights estoppel, clearly the city has confirmed somewhere along the line that this duplex was permitted. Okay. And notably, like Ryan indicated, the city relied on the Citus document to confirm what the zoning was under chapter 43 and 43A. City has not even presented, Mr. Schwab, any kind of zoning map at this hearing. That's how much they relied on Citus, okay, as the gospel in terms of what the zoning is. You haven't seen a map. The only map in the record right now is the one I provided, which says the property was zoned R2 in 1951. The evidence supports pre-1956 non-abandoned duplex. If you're going to rely solely on the property appraiser record card that shows 1962, here again, going back to Citus, is there was a permit issued for this structure. So under the doctrine of vested rights or equitable estoppel, it would be considered a lawful non-conforming use. So we think that the recommendation to City Council should be to reverse Mr. Cotton's FDN. And if you have any questions, we'll try and answer those.
Just the exhibits. So it looks like from the original list, there were the inclusion of the official map and then also the photos. If you could mark those,
Okay.
Perhaps as F and G, because your original exhibits were A.
The photos were in the PowerPoint presentation, and then the zoning map is listed in our hearing exhibits as item exhibit 4. And you don't have that because again, we thought you were going to be here today, so we printed out a paper copy of it.
Yeah, if you don't mind just marking those so they're identified as F and G, even if they're not sequential, because what I have is petitioners exhibits A through E that were emailed to me that consist of the formal decision application, boundary survey, original property tax.
Derek, that came from city staff or city attorney's office. We didn't provide our exhibit list until today.
All right. So does your current exhibit list include all the items that you've shown at this hearing?
Yes.
Okay, great. If you could forward that to me if you haven't already with those exhibits, just so that I can clearly identify in the recommended order what was presented, that would be helpful.
Will do, sir.
Mr. Bentley, at this point, do you have any questions for Mr. Massey?
For me.
No, I don't.
All right. Attorney Pettis-Mackle, do you have any questions for
Yes, I do.
Mr.
So this is to whoever there's both testimony from both. When you testify that the city staff relied on the Polk directory information that was submitted, that Polk directory information was submitted by the applicant, correct?
It may have been. I'm not aware of it.
You're not aware of what was submitted by the applicant for the FDN?
Yeah, off the top of my head, I'm not. I think that's irrelevant, okay, because the code says Polk directories that cities shall consider those. if they're available too.
That wasn't my question. So,
I don't care what your question was. It's,
Let me interject right now. I think it would be better to direct these comments to Mr. Massey. Mr. Bentley wasn't even sworn in, I don't think.
I don't know that
And then
anyone.
Mr. Yeah, Mr. Massey, and I'm pronouncing your last name correctly, am I not?
Manasseh.
Manasseh, I apologize, sir. I thought maybe I had it wrong. So Mr. Manasseh,
you were sworn in, weren't you?
No, I
the
didn't.
testimony, were you sworn in?
No.
All right. So if you could please raise your right hand, I'm going to do a modified oath. All right. All the testimony that you previously provided, was that true and correct and deemed to be under oath at the time you made it?
Yes, sir.
And do you swear or affirm that you will henceforward tell the truth and nothing but the truth?
Yes, sir.
Okay. If you don't mind, Attorney Pettis, address your quick questions to Mr. Massey and Mr. Manasseh, and then Mr. Bentley can make whatever objections he deems appropriate, and then I'll rule on them.
So, Mr. Manasseh, when it was testified earlier that the polk directory items, the applicant for a formal decision, they are required to provide information to support their application, correct?
Correct.
So in reviewing for the request, it's the burden is on the applicant to provide the information to support their request that they're asking for, correct?
Correct. And the applicant did. We didn't file the formal decision. We filed the appeal.
That's fine. So in reviewing the information that was submitted by the applicant, and now this is today as a de novo hearing, there's been no, as testified before, there's been no permit to show, building permit to show the legality of the legal, that it was legally established or permitted as a duplex, correct?
I think that's incorrect. You had Eric testify about Citus was a combination of permitting system and other information. Citus information indicates a duplex.
So it's just the Citus document that was submitted by the applicant that you're relying on?
I'm not sure if that was submitted by the applicant because city staff's the only one that has access to that. So there had to be conversation between city staff to get that document.
Okay. So is it possible in 1962, it's possible that some buildings are built without a permit, correct?
Of course.
Okay. And you testified that in your previous employment with the city, you also looked at the rental certificate program to determine use or what the use was regarding a matter?
Sure, I could elaborate on that. When it came back through zoning, the city had thousands of records of rental certificates that had to be approved. And so code enforcement sent them to zoning, and you could verify this with staff. I think all of the staff planners got assigned rental certificate cases. Some staff planners had access to Citus, some don't. I had access to Citus because I did rezonings as well. So and alcohol petitions, and we used it regularly to definitively determine the last legal use of a property. So in those cases where the rental, as referenced in my testimony, the rental certificates, one of the ways is either everybody in the city of Tampa getting a rental certificate would have to go through a formal decision, or zoning staff would determine that through the information Citus or other permitting systems that there's enough to say there was 2 legal units so you can have a rental certificate. So in that case with the rental certificates, if I were to take this information from Citus, I would have issued a rental certificate for 2 units.
So if there's a record showing associated with a property that a rental certificate was not given for a property, is that significant?
So let me elaborate on that. I don't think so, in my opinion, because it depends on who reviewed it. Because not everybody had access to Citus. So somebody might have had access to Excella, which only goes back to 2014, 2016, somewhere around there. So if they typed in the address in Excella and nothing came up for permitting history, and they checked with construction services and nothing was there, if that planner didn't have access to Citus, they wouldn't see that same information. And I'll testify that I was one of few people at zoning that had access to Citus.
So, okay, if I just may have one moment.
Sure.
Okay. I have no further questions for this witness.
All right, Mr. Bentley, do you have any follow-up questions for Mr.
Yeah, just
Manassi?
one for Mr. Massey. Ryan,
You got my name now. Derek, you got him to change my name.
Everybody forgot his name.
what? I said Manasseh.
It's okay. I've heard every variation.
Didn't I say Manasseh?
No.
Yeah, I just came back from Peru, man. I'm all messed up.
I've always put an E at the end of his name, 2 E's.
He'll forgive me, I hope.
It doesn't matter.
But anyhow, in your professional opinion, based on your experience, especially as your time as a city employee in the zoning department or development services, I'm sorry. If a use is identified on the situs record, okay, is the last legal use, would that generally indicate that it was a permitted use?
Yes. I mean, from my last position, leaving as planning development coordinator, we'd use Citus to look up the last legal use on rezoning applications. And actually, when I did alcohol petition, it was the same thing. So if you had access to Citus, you'd utilize it to figure out the last legal use. Because again, as I think Eric mentioned earlier, city records can be spotty after a certain amount of time. It depends on what information we have. So.
Derek, that's all I have. Thanks.
All right, and Mr. Bentley, do you have any other witnesses or evidence that you'd like to present at this time?
No, thank you.
At this point, we'll allow for public comment. Are there any members of the public who would like to speak on this matter? Okay, seeing none, we'll close the public comment portion of the hearing. The city, do you have any closing remarks at this time?
I don't know if we want to, can I just have one moment, please?
Yes, absolutely.
So, Mr. Schroth, on, again, proposed rules of procedures, number 5, I'd asked to be able to recall Mr. Cotton based upon what was previously, based upon what was testified to.
Sure. You have the ability to do that as a rebuttal witness.
Yes. So I asked to call Mr. Cotton.
All right, Mr. Cotton, you've been previously sworn in. Please proceed.
So I just want to clarify some information regarding the Citus database. The information is that's in that database when it was created in the mid-'80s, pulled information from a number of resources, put it in the property appraiser's office, so that the SLUC code that is in the database would have been pulled from the property appraiser. So if they showed the use as being a duplex, that's what we reflected in Citus. This property actually did apply for a rental certificate in 2017 and was denied. Rental certificate with the comment about seeking a formal decision. The property owner at the time did not apply for it. I know they were then cited in 2019. I don't know if this is the same property owner or not in 2019 for a use with the same solution, get a formal decision. The database is used for information, but it's just one of a number of things that we look at. Because there are cases where the SLUC code will say it's a quadplex, but the last permits they've ever pulled on it were for single family residential. So it's just a database with a moment in time when information was put into it. And there's often information that's so just another one of those resources that we use when we look at stuff. For this specific case, it comes down to the property appraiser says it was built in 1962, and the zoning went into effect for the R1 zoning in 1956. That's the basis of that. Basically summarizes our position of how we came up with the determination of it was not legally established.
And Mr. Cotton, does the Hillsborough County Property Appraiser's Office, do they, in the information that's on the Hillsborough County Property Appraisers, do they look to the city permitting program to determine if there was a permit applied for?
Back in that time frame, no. Today they do. Today permit information is available on the property appraiser's office.
But at the time that this property was built and the information that was pulled from Citus, that connection did not exist.
No, ma'am, it did not exist back in the 60s.
And the information that was inputted into the CITUS program that might have been sourced from the Hillsborough County property appraisers, that would have been obtained from that information, or that data could have possibly been obtained from the property owner at the time, correct?
Correct.
And not necessarily confirmed with the city of Tampa about whether it was legally permitted.
That is correct.
I have no further questions.
I've
Thank
got
you,
a
Mr. Bentley. Do you have questions?
I do. Eric, what if Citus would have said 1956 year built? Would you have questioned that as being ambiguous?
Status doesn't reflect, I don't believe reflects the year built in it. So we would have looked at that.
Okay. You indicated that Citus collects information from different sources, okay? And sometimes that can be questionable or ambiguous, correct?
I guess it came from different sources, yes.
Pardon me?
It does come from different sources.
Can you tell me the Citus?
You want to pull all the screens?
Yeah.
Do you want it on screen or?
Just a copy of it. So I'm looking at the Citus document and it says SLU code duplex. You're saying that comes from the property appraiser?
Yes, sir.
So why would the property appraiser characterize it as a duplex if it was a single family home?
The property appraiser, if I convert my house to a triplex and the property appraiser is aware of that, they will call my house a triplex. Because it's a taxing entity. They're just, whatever the highest and best use they can tax it for that's physically there, they will tax it for.
Yeah, but on this particular Citus, it indicates in like 3 or 4 different locations on the document that there's a unit A and B. Pardon me?
2 residential units.
Yeah, 2 residential units. So that didn't come from the property appraiser, did it?
The addressing and when that was done was either from the city of Tampa, or it could have been, remember, if there's a unit out there or a building, it has to be addressed by E911 standards. So if there were 10 units in there, they would have 10 different numbers or letters assigned to them. That's a requirement of E911.
Mm-hmm.
So that's where that information gets pulled from.
Okay. So here again, Citus says, in, I think 4 locations, there's units A and B. And you're saying that the address identification comes from the city of Tampa.
That's my understanding, yes.
Yeah.
Because of 911 requirements.
Okay. Is there a possibility that a permit was issued for construction of a duplex by mistake by the city?
I can't testify to that, but mistakes are always a
So
possibility.
that there was a possibility.
Possibly, yes. I can't testify to that if it was or not.
Derek, that'll do it. And just one final comment here again. I cited the cases early on. In the event that there's any doubt or ambiguity or question about land use regulation or application thereof, that should be construed in favor of liberal use of the property by the property owner.
Understood. At this point, does the city attorney's office have any closing argument?
Yes, I do, sir.
Please proceed.
Thank you. So I provided already a copy of code section 20.27-61, which governs the review process. And in the code, that code specifically states in 27-61, subsection J1C, 3i, that the burden of proof for this hearing is with the petitioner. You heard testimony, you will receive documents that the continued use of this property was a duplex. As testified by Mr. Cotton, the code specifically addresses nonconformity. In order to establish a nonconformity, the petitioner would have to, and the applicant would have had to provide or establish that it was legally permitted building in order to show that it was a non-conforming, the consistency with the non-conforming use. There's been no presentation, no evidence submitted that a permit was issued to legally establish this property as a duplex. The code, when you review the code, does not allow Mr. Cotton the authority to waive the requirement to, in that determination of legal nonconformity. If he testified that he did not review a permit associated with this property, and therefore he had to deny the request for legal nonconformity on this property. The city would ask that the hearing, that you, Mr. Schroth, as a hearing officer, deny the petition for review and uphold the decision of the zoning administrator.
Derek, I just have,
All right, thank you. Yes, Mr. Bentley, do you have any closing remarks?
yeah,
Before
just
we
a couple
conclude?
comments. Ms. Pettis-Mackle indicated that there's no evidence of a legal permit being issued for construction of the duplex. And I guess I'd have to agree with that. There's no permit. And I think it's just fundamentally inequitable and unfair that the city takes a position, hey, you can't, you're going to lose your status or you're illegal. And oh, by the way, we purged our records of the evidence that you would need to demonstrate to satisfy us that it's legal non-conforming use. So they trash or purge all their records, then they turn around and throw it in the property owner's face saying, hey, you know, you should have had a permit, and say, well, there's no permit to be found. Okay, so what's the best evidence the city has? It's the situs information, which indicates, okay, that there was a permitted structure on that property. Okay. It's my understanding if something was illegal, it wouldn't be provided or put into the situs records. So that's, in this situation, we provided the best evidence we can to demonstrate that's the legal non-conforming duplex. Okay, along with the zoning map. Now, probably a plausible explanation as to what went down would be because I showed you the zoning map, it said R2, you know, maybe some reviewer or whatever just looked at that map because that was in existence till 56. And the code changed in January 1956. It's my understanding, okay, when it went from the R2 to the R1 under chapter 43 or 43A. So, you know, maybe here again, that's speculation, but I don't think a property owner should be penalized. They've been paying taxes as a duplex for the last 50 or 60 years, and all my clients' predecessors in title. You know, they kept the property in compliance. The evidence shows that, you know, the construction was, if you compare the footprint under the property appraiser card from 62 to the ship photos like we showed you today, that absolutely nothing has changed. Okay, so I just want to make that clear that it's, you know, this suggestion that we didn't provide the best evidence. Well, the best evidence doesn't exist. So thank you.
Thank you. Thank you all for your time today. If you could submit proposed recommended orders by December 17th to me in Word format by email, I would appreciate that. And Mr. Bentley, if you need some prior orders of mine, you may have them from other cases. I'd like the exhibits referenced by letter or number, and then a brief description of what they were, both from the city and from the petitioner side. If there are no further comments, I'll close the public hearing. Are there any further comments?
No, sir.
Thank you. Appreciate it.
We'll close the public hearing then on FDN 25-156. Thank you, all of you, for your time. Appreciate it.
Thank you.